DM. Present in the virtual courtroom, we have both parties along with their respective attorneys, Mr. Vandenheuvel on behalf of Ms. Hatley and Ms. Reisberg on behalf of Mr. Hatley. We are here on a number of motions, actually. We've got the defendant's motion to modify the temporary order and appoint a GAL. We've got the plaintiff's motion to enforce counseling and the plaintiff's motion to enforce the status quo. So who wants to go first, or what makes the most sense?
I will
to go first because I have the two motions and about the status quo and the counseling, and I think they will help enlighten the other issues, Your Honor.
Those are also the subject of my motion that I filed several weeks prior to Mr. Vandenheuvel's.
Right, let's go with the first filing, Ms. Reisberg.
Thank you. The court is aware.
And let me, I've read everything.
Yep,
I spent quite a bit of time reading it last night, just so you know.
Yep.
So you don't need to repeat everything.
I was just going to say that I know that Your Honor is very thorough and reads these things. So I'm not going to beat everything to death again. I will just comment on a few of, just to outline the structure again of what we're asking for. We are looking for an order for separate finances. Mr. Vandenheuvel is arguing to maintain the status quo. We are also ordering to enforce, asking to have counseling enforced. He's also asking to have counseling enforced. So all of his issues are contained within our motions already. We need some relief on personal property, payment of college tuition, appointment of the GAL, a request to stop recording the children in the home, and a no contact order with Mr. Wright. Mr. Vandenheuvel has responded to my motion with a lot of commentary that my statements about his failure to respond to me and functionally ignoring my request to resolve these issues are personal attacks. They're not, they're just facts. We're here today because I have not had any substantive response on these issues. It's been months. I've been trying to work them out because the status quo in particular with regard to finances instantly crumbled. You know, there's allegations in there about my client being a Christian fundamentalist. I don't even know what that is. I don't know that Mr. Hatley knows what that is, and that he's a far right woman. Basically, that he wants to own wives and he thinks that they're personal property. I don't get this from Mr. Hatley at all. He's actually hired a female attorney. So, I mean, we're just looking at these bizarre sorts of allegations here. With regard to the separate finances, I would really like the court to understand that there is no status quo anymore. These parties cannot communicate about anything. So it quickly deteriorated. We went through and did the math. What was going on was Ms. Hatley was grossly overspending, and my client would deposit his paycheck and she would take it. And I did the math, and there are, with assistance from my client, she took 49% of the dollars that he deposited, put them in her own accounts or used them for her own purposes, while my client paid 100% of the bills. He was also giving her $1,100 a month still. So any suggestion that she didn't have money to buy gas, you know, again, she's sitting on $15,000 she took initially. We didn't have any choice but to stop. There was no communication from Mr. Vandenheuvel about these issues. He's alleged that she can't work because of daycare. That's just a falsehood. I mean, the children are all in school. She's a trained occupational therapist. We know it'll take her a little bit of time to get back in and recertified, but she can work as an assistant now. She's made no attempts, as far as I can tell, to do that. The older kids are 15 and 16 years old and are certainly able to watch the younger ones in the summer. With regard to support, you know, we would just like to see it referred to the FOC for child support, effective date of February 1st. There's no way the status quo can continue. She's got a whole new home. There's no marital home. And my client should not be responsible for whatever arbitrary bills she decides that she wants to sign up for. He had no decision-making authority for whatever she has at her new house. So, and the tuition, to me, it's just a no-brainer. She agreed to pay it. They've got the funds from the proceeds of the house to pay it. She owes her $8,000 to Mr. Hatley. Coming to the issue of personal property, there have been new developments since the time I filed this, Your Honor. As you're aware, we filed this back on, I believe, January 10th, set for hearing on the 19th. We always knew that the parties were going to be vacating the home Well, Miss Hatley's been in it by herself for the past several months. They were going to be vacating the home. She was on February 1st, is what we understood, but she wouldn't give us an answer about that. And so we've been asking for months to get in there, right? And I'm getting no substantive responses. And we finally, after threatening an ex parte motion, because Mr. Hatley or Mr. Vanden Heuvel asked for an adjournment for the death of his father. Of course, I granted that adjournment. Absolutely. But what it did was move this to the next date of February 2nd. So it was very clear that we have personal property issues we're going to need to address before Miss Hatley moves out and my client doesn't have any chance to go through anything. Again, ignored. So I finally threaten ex parte relief and sanctions, have to draft the motion. My client spends a lot of money in doing that. And they say, okay, he can do a walkthrough for like an hour or two, a day or two before she moves. So we have more correspondence about how that's not going to work. Finally, they agree to a little snippet of time over this past weekend, and my client gets there and the house is cleaned out. It's a swamp, it's dirty, it's not in the condition for the new owners to take possession, and everything's gone, the tools are gone, stuff is boxed up. There's no meaningful way for him to go through this stuff, which is what I was worried about, which is why I was asking for months. Same thing with the storage unit. You know, they give a window of time for 1 hour on the 31st. My client gets a text from Ms. Hatley at 6:18 p.m. They had agreed to do a walkthrough from 6 to 7 p.m. The text comes in at 6:18 p.m. from Ms. Hatley saying, this is the address of the storage unit. I'll meet you there in 20 minutes. It would have, that puts them at like 6:48, I believe. So 6:38, so 22 minutes for him to look through a storage unit in the dark. So what we're asking for on personal property, Your Honor, my client has been completely cut off from any meaningful way to see what's still in that home. He left with a couple of items to furnish his new rental and, you know, his personal clothing and stuff like that. So we would like the opportunity to be able to get into Miss Hatley's new home, which is where we suspect all of this stuff is now, and the storage unit in the daytime when it's light out, to see what Mr. Hatley wants to make a claim to, and in order that Miss Hatley give us a detailed inventory of anything she sold, liquidated, or given away within the next 14 days, and that we have an opportunity to do the walkthroughs within the next 7 days. Again, he's lost all of his personal property because we weren't allowed any access. And I know that I can deal with that in the final property settlement, because at this point, like, our window to deal with this has kind of diminished, but we need some sense of what she's liquidated and an option to look at this stuff. Moving to the issues surrounding the children, you know, I've outlined that in there. These, you know, we do agree that there's alienation going on, I'll say that, but we believe it is the mom alienating herself from her children for the reasons we've outlined in our motion. There's these explosive fights between her and the kids, and she's body camming, recording these kids walking around. They feel like they're being spied on in their own home. The 2233 isn't working. We just want like a week on, week off, so there's less contacts with these parties. If they truly believe that my client is alienating these kids from Miss Hatley, as Mr. Vanden Heuvel claims that Mr. Hatley is, then I don't see why there's any objection to a guardian ad litem at all. And the parties are sitting on several $100,000 from the sale of their marital home, so there should be sufficient funds to appoint and pay for a guardian ad litem. Mr. Vanden Heuvel suggested that I want to use Donna Mobilia. I've not suggested that, and that's not likely. I would prefer Stacy Van Dyken, Charlie Clapp, Margaret Allen, really anybody that the court trusts to do that role. In terms of counseling, we've tried our best. We agreed upon counselors at Psychology Associates. They're not even telling us anybody specific they want to use. She just wants her unfettered discretion to pick somebody. And she's finally saying in network, after months of throwing just a litany of out-of-network counselors in front of my client and saying, why don't you pick one? Well, there's 5 kids. I mean, they will go broke. if they have to pay for out of network for all of these kids. Psychology associates, we picked 2 people from there. Neither one was available, fortunately. No reason we couldn't go back to psychology associates and find somebody else. They're reputable providers. I would think the court trusts that entity, or send the kids back to Billy Robinson, who was their previous counselor. There was never any problem with them going to him until these parties started into the divorce, and it was Miss Hatley who unilaterally said they're not going anymore and changed the status quo on that. So we'd like to see them go back. The issue with Jeff Wright, the brother, again, that became kind of a moot point because we got stonewalled again on the issue because the hearing got adjourned at Mr. Vanden Heuvel's request, and he wouldn't really respond to me about it in the meantime. So in the future, moving forward, this person who, in essence, told the party's daughter to burn in hell is not somebody who should be around these children. He has a drinking problem, as far as we're aware. The response from Miss Hatley on this issue is that, well, the daughter was cursing out the mom. Well, that may be true because their relationships are absolutely in the toilet with their mother. But that doesn't give this grown man the right to tell this child in so many words to burn in hell and to call her phone off the hook on a Tuesday, Wednesday night.
And again, I've read all this stuff, so
I'm done. But essentially, our primary focus here today is to separate the parties' finances, send it to the friend of the court, get a counselor appointed, do something about this personal property issue. Thank you, Your Honor.
Thank you, Mr. Vanden Heuvel. And let me just say, I would agree with Ms. Reisberg that I think you can probably conflate your motions kind of in your response to Ms. Reisberg if we can. Otherwise, we can take them individually, but I think they're also interrelated. If you could sort of combine them in your oral response. And I've read your motions as well. So
Okay. So I can probably, and to try to keep things on the starting with what Ms. Hatley or starting with what Mr. Hatley's attorney addressed first. And that relates to our status quo order. What's interesting about this is we have this order, we put together 2 stipulated orders, we agree. And by the way, the status quo order was not my suggestion, it was the other side's suggestion to put together. We put together the status quo order early. We start working on it already in August, September. As you know, the court signs orders. We reaffirm it in a second order. His responses, which is interesting, is he admits that he's not following the order that he asked for. He doesn't provide the monies that he says. He says, but I'm in the spirit of the order. But he's not sending the money. And I laid out carefully in our petition each and every instance of failing to send the money. And it was interesting, admitted but, oh, it's in the spirit, admitted but. So he says, yes, but I'm paying all the bills. But that's not true either. He's not paying the kids' basketball fees, the driver training fees, leaving money for food and gas. And not the point of the order was we sit down with a checkbook and we write all the bills. Not once did he ever do that. Not once did he ever sit down and here's the list of the bills. Here's what we're going to go through. Here's what we're going to write and we're going to divide it out. No explanation whatsoever. Then he says in his response to the motion, he says, my client is a hoarder. She's hoarding all the money in her accounts. That's an interesting thing, but my observation of that is in the motion here, there's not one example of hoarding or overspending of any kind because there isn't any. In fact, my client would like to know where the hoard is because she could use the money for the kids. The truth of the matter is that he has been taking the money, spending as he wishes, hasn't followed this order from the inception of the order, has violated the order, leaving my client without money often. And I illustrated one of the points where there was no money for food for the kids. She gets rejected at the grocery store because the party's credit card won't even go through and he hasn't left money enough for them to do that. And yes, that is extremely distressing to be in a grocery checkout line and you simply don't have enough to buy the $100 and some of groceries for your kids.
And again, sorry to interrupt, but I've read most of this. I don't want to spend a lot of time.
Okay.
If you could just summarize it a little better.
So there's no examples. There's no you know, he keeps throwing out these allegations, but the one thing we can see from observation is that he's admitting that he's not doing what he's supposed to do and paying, and there's quite a bit of my money that my client has owed through this whole thing. The other thing that's interesting in this, which I didn't put in here, is in one of the previous writings to my office, they asked if he could give a car to one of the other kids. And we're like, you're saying you can't afford to make these payments and you want to give the child a car? Now he makes somewhere near, according to his tax returns, $330,000 in 2022. The year before, I think he was somewhere around the $700,000 mark. This is not somebody who doesn't have funds. He's president of a company. He is able to do this. He keeps flipping, flopping, and saying, I can't do it. He does. So we're asking that my client get paid back because she's got bills. She's forcing to use all her resources, drain everything and use credit, whatever she can get her hands on to take care of this. Now, just to put this in context, they've had 8 children together. 5 are with my client, 1 with him, 2 are out of the house, and she raised one of his kids. So I'm going to switch over. That's the financial piece of this, is to say, and then they say, oh, you need to pay half the college tuition bill. My client's been a homemaker for all 20 years. Where's that money coming from? Especially when you don't pay. So I'm going to shift gears here to the counseling. This summer, we put together 3 counselor recommendations that were within their community. My client asked for it. They rejected it because they came from my client. My client then went forward and asked the first order that the court put together, said, hey, we're going to do this. We need to do counseling, work it out together. A rejection of all names. We come up in the second mediation with 2 names. We send it there. The 2 names. She faithfully goes to the 2 names, tries to set up appointments, and the Mr. DeWitt reports, hey, we don't have counselors available right now, and neither I nor Mr. May have the ability to take you. But here's a list of 6 people, 5 in network and 1 out of network, from a group that we would highly recommend because we're at capacity right now. Go see these people. My client immediately, in the order that was signed and stipulated to by the other parties, said we'll get this counseling done by November 26th. It's going to be done. My client works diligently, supplies the 5 names. Well, you know. So in his motion, it's interesting. His response to our motion, he says, well, this was, quit giving me homework, quit, forcing me to do this. And in his response to our motion basically says, I'm too busy for this. I don't have time to vet these people. You need to vet these people for me. They've already been vetted, Your Honor, by the counselor. They agreed to. This is the people that were put forward by Mr. DeWitt. Still no action. We are. We started this in summer. Never any suggestion that my client brings forward, vets, looks at. We've put tons of counselors forward, and we can never, ever pick the counselors that are recommended. Now, Mr. DeWitt's vetted these, said they're all good. Pick any 2 of these counselors. They put in their motion, psychology associates, they said they don't have capacity. That's why they recommended this other group. That's why Mr. DeWitt wrote the letter and put the 5 names forward. He has blown this off. He said, I don't want your homework. I'm too busy. And in the response to the motion, it was the same thing again. Let's pick one from the Centennial Counseling list and let's get this over with. And we put that forward, and this has gone on. Now I'm going to go to personal property because that's been raised. And I'm trying to be systematic. Back last summer, we had Stanton appraisals come and go into the home and the cottage of the parties. And it made a list and appraised all the personal property, put it all together way back when. There is a definite list of what there is. This fall, Mr. Hatley asked to open. My client started packing because it's like, hey, I got 6 kids here plus myself. We got to start packing. We're selling this house. He had insisted that every box had to be opened and looked at and inspected. My client said, fine, look at it. Whatever you want to look at. Now, bear in mind, we've got Stanton appraisals, comprehensive list of everything that's there. In December, on the 12th and the 26th, via text, and I have copies of those texts, and I've submitted them to counsel. We offered, my client said on the 19th and 26th of December, said, hey, come on over here. If you want to once again look through all the property, please come and look. Crickets. No response. Refused to answer. Mr. Hatley even refused to bother to answer. So then counsel reached out to our office again, said, hey, we need to have these inspections before they moved. We made arrangements. We first said, no, this is not moving things, Your Honor. This is just making sure I've got everything and we have an agreed upon list. This is not about moving. How long do you need? We need 4 hours. 4 hours? Why do you need 4 hours to walk through the home again? We argued, we said, we can give you an hour there, an hour at the storage, done. Oh, no, had to have 4 hours. Fine. 2 hours at the house. He came, he did an hour. He looked, he left. My client then set storage and said, I've got the stuff in storage. It's a well-lit, high-security storage place. This is great. You can come, spend your 2 hours and look there. Right before the appointment, she realized, I haven't, and he didn't call and say, oh, where's the storage or anything like that, but she texted him, and it's right by his house, by the way, said, hey, let's meet at the storage. I'm about 20 minutes out. I'm running a little late, but we can do the storage, and here's the address to the storage. He just didn't come. Didn't bother to come to the storage. Now, I don't think, to be honest with you, this is the second accommodation, and it's in a second look in addition to what Mr. Stanton has put together. And I shared Mr. Stanton's list with opposing counsel as well. I think this is a non-starting issue. It is just part of the ongoing resist, refuse, insist, refuse. It's the push me, pull me all the way, resulting in that. Now, we need to get the kids in because there is alienation. And you heard counsel say, we think she's alienating herself from the kids. I will tell you, not likely. This has been a 20-year marriage. She has raised 8 children of their own, one of his from a prior relationship.
Again, you're repeating a lot of what was in your motion, so I don't want to take up too much time.
Yep. So that's, we're saying there's no need for GAL, but there is a need for counseling here. We don't need that additional burden. She's raised these kids. She did the homework. She did the laundry, cooking, cleaning, took the kids to their events and did all the medical appointments. She's done an outstanding job with these kids. There's no doubt about that. And I just think he's a little bit clueless about what really goes on. This woman is run this household, but had to get away because of this kind of behavior, this controlling, I have to be the person in charge type of behavior. And it's driven my client to the point when she realized that he would not honestly engage in counseling. She said, I've got to save myself because this is just too much. My body is deteriorating. I'm deteriorating because I can't do this. Now, last thing, the body cam. When he was in the house, he was constantly gaslighting my client. My client took to wearing the body cam when he was around to stop that from occurring because he wouldn't dare do it in camera. And it did in fact stop it. He then asked the children to take their phones and tape my client whenever something was not to their liking. My client said, if that's the case, the body cam goes on or it can go off and everybody's phones go away in a bin and we live together in peace and harmony. Well, neither of those things occurred. When he moved out, the body cam pretty much went away most of the time. Unless he's around her in 6 change, she wears it because she doesn't want him to gaslight her and do other crazy stuff like we're hearing here today. So does she use the body cam actively at home? No, she doesn't. But when he's around, yeah, she does. So with that said, Your Honor, I would ask for our attorney fees. This is a clear violation of the order. We knew about the counseling. The counseling's been offered. It was ordered. He agreed to it. It was stipulated in 2 separate orders. The status quo payment arrangement was violated right from the inception. They admit they violated it. They said it's in the spirit of things. They haven't followed the court's order. They were supposed to do this arrangement. They throw out statistics. Oh, this isn't. We have no idea. They've never shared any of that. And they didn't do the bills together. They violated the order right from its inception. My client's owed some very good money here and needs to be paid back so she can pay her attorney fees that were provided for in the order that they would be paid, pay counselors, pay these other bills, and be able to decently live without going to the grocery store and getting your check or your card no longer has money on it message. Thank you, Your Honor.
Thank you. Ms. Reisberg, I kind of don't want to give you rebuttal time just because of the time that this motion is taken, but I do have a question for you.
Sure.
The Stanton appraisal, was that not comprehensive?
It was never agreed upon, Your Honor. We said from the absolute beginning, we didn't want Mr. Stanton to appraise the property. That was done without our consent, was my understanding. He went out and got it and forced it upon us. The Stanton appraisal is also categorically arranged and isn't, he'll lumps things together. It wasn't something that we ever agreed to as being a comprehensive way to look at the party's personal property. No. Mr. Vanden Heuvel ordered that appraisal.
But we did make arrangements for the appraisal to happen at the northern property, and council did cooperate with her client in getting a time set. Thank you.
Because I believe that you're entitled to an appraisal if you'd like one, and I cooperate with opposing counsel's requests. So that was why it was permitted.
Okay. Is there anything that you
Yeah.
can briefly rebut? But it's got to be brief because I've got another case waiting.
Yeah. Miss Hatley has taken $16,000 from the joint accounts cash that she pulled since September 29, and Mr. Hatley has paid 100% of the marital bills. No, he didn't pay for basketball or driver's training, but I think that pales in comparison to all of the bills that he's paid. He also paid $43,000 in joint credit card debt out of his share of the marital proceeds. That was all money that should have been shared. Well, the $43,000 should have been shared equally, and a lot of that was Miss Hatley's spending. He made $221,000 in 2023, nowhere near the numbers that Mr. Vanden Heuvel's talking about. He also has 50-50 parenting time with the kids, so the kids don't live with him or just with Miss Vanden Heuvel or with Miss Hatley as has been represented. And the recordings, yeah, she was still recording after Mr. Hatley left. She's also been recording the parties and the children talking without being a party to that conversation. And my understanding is that's a violation of criminal law. And that's all I have to say. Thank you.
Okay, thank you.
I have a response, Your Honor.
I don't want, we're not going to go back and forth like this. We're done. As far as parenting time goes, I do believe that there needs to be a modification in parenting time. At the very least, it's apparent to this court that these parties we need to reduce the time these parties are in a communication with each other or contact with each other for exchanges. Mr. Hartley has admitted in his argument that there's, or at least believes that there's gaslighting going on when there is contact. So again, another reason to limit the contact with the parties. So I will grant the request that it be modified to the 2255 schedule as requested by the defendant. I think that will help lower the temperature. I do believe, based on the allegations, frankly, from both sides in this case, that a guardian ad litem absolutely is appropriate. And I will appoint Margaret Allen, if she's willing to serve, as the guardian ad litem in this case. With the defendant paying for that, at least initially, and then it can be worked out, the split can be worked out in the final property settlement. Neither party shall record the minor children other than for memorabilia purposes, regardless of what's going on. That's just not appropriate. And if the children are recording at the behest of either party, then both parties need to confiscate those phones and put them away so that the kids don't have access to them during parenting time. That's literally putting these children in the middle of this dispute, and it's horrible for them and their long-term consequences. So I don't want either parent doing that. I'll grant the request for no contact with Mr. Wright. He's not a part of this case. He doesn't have any kind of visiting rights legally, and so that's a no-brainer for the court to prohibit him from having contact, at least on a temporary basis, until this divorce is resolved. The parties are to choose a in-network provider on that list that Dr. DeWitt provided previously. And I think that was what, 4 that were in network, Mr. Vanden Heuvel? 5? Okay, so pick one of those. If you can't, contact my office. We'll have a case conference in the next week or so, and I'll choose. But I would hope that the two of you could do that with counseling to begin as soon as there's availability on the counselor's schedule. I might have missed it, but the app close, Ms. Reisberg, did you mention that, the request that those calendars, appointments, and all of that be provided on that?
That was in my motion, Your Honor. I didn't address it orally, but yeah, we need better compliance with app close.
Great. I'm always in favor of that. I think those apps are great, regardless of which one it is, because again, it provides guardrails, barriers, fences, as well as accountability. So the more information that's placed on those for both parties to see, as well as providing a record for the court in the event that there's a dispute. It's good communication. So I will grant that request as well. As far as the financials, it's clear again to the court. I mean, these parties are getting divorced. The status quo order did not work, regardless of whose fault that was. And I don't think it's clear. I think perhaps there's fault on both sides for it not working, as often is the case in these cases. But we need to make a change. I think based on the situation of the plaintiff in this matter, she clearly is entitled to some spousal support. And I don't think that the defendant would argue that she's not, given the circumstances. For the time being, I would order that Mr. Hatley pay all of the expenses, so long as they are the ongoing regular bills. But Ms. Hatley is going to clearly be responsible for her own personal expenses, not related to the children. And again, I would hope that the attorneys could hash out what those bills are, and put a number to them. Let's see. I will refer the issue of child support to the front of the court for an investigation and recommendation with an effective date of February 1st. I will permit the defendant to do a walkthrough of the defendant's home in the storage unit, again in daylight and perhaps with his own appraiser, to determine whether or not the Stanton appraisal is comprehensive. And that's to be done within the next 14 days. So that we can put that issue, at least as much as we can, to bed. Order that neither party sell or liquidate personal property until further agreement. And nobody mentioned the smoker. Has that been turned over?
It hasn't been, because it's part of personal property, Your Honor, and they have not come to an agreement on the personal property. And it's just trying to pick out little pieces here and there of things I want. A lot of it's been
All right.
divided.
I'm gonna order that the smoker be turned over. We can value it at some point if it hasn't already been valued.
Time frame on that, Your Honor?
14 days. I'll make it the same as the walkthrough.
Okay.
And the issue regarding the tuition, I'm going to reserve for trial or ultimate resolution of this case. And let's see. Was there anything further?
I have
Your Honor.
the list of anything that she did liquidate and what she sold it for. Could we have that within 14 days?
There's nothing liquidated. We can make that easy.
Okay. I think that's appropriate.
Okay. And I do have a question, just to clarify on the app close. My request was that the parties be required to calendar any sort of, appointments or extracurriculars for the kids within 48 hours of themselves receiving that information.
I'm granting it as planned.
48 hours. Okay, I just wanted to clarify.
Yep.
And then in terms of the parenting time being 2255, my request was for defendant to have Monday, Tuesday, and plaintiff to have Thursday, Friday. You're granting that as requested?
As planned.
Okay. And just a clarification on the payment of the regular bills. I'm truly not trying to argue with Your Honor. I'm just not sure that I understand. I have run guidelines on this, and it's about $1,700 in support for child support to Miss Hatley, and about $2,300-ish in spousal support, as opposed to the parties, because saying that the regular bills will be paid is really difficult and kind of nondescript at this point, because Miss Hatley has an entirely new residence. I don't know if she has a mortgage. I don't know who she pays for with cable.
All right. Thank you. Have you shared those calculations, the prognosticator, I assume, and the support child support, with
We have not come
Mr.
to an agreement, Your Honor,
I
on
have,
what child support and child support should be. I have a different figure, obviously, and that's one of the things we have not come to agreement on. My client had paid a $2,000 bill related to their timeshare and would like reimbursement for that as well. That was not paid, as well as the kids, basketball and the
All
other
right. I'm gonna, I guess, reserve on that. I'm just, again, that's why I thought maybe the attorneys could get together and try to resolve this because, the mortgage, the utilities, all of those things should be very easily discernible, to figure out. So, and my thought was to make sure those are paid pending the resolution of, the child support and spousal
Thank you.
support.
Thank you, Your Honor.
I'm concerned because I genuinely, so what are you ordering that Mr. Vanden Heuvel and I exchange a list of what Miss Hatley's regular bills are, meaning mortgage, cable bill, things like that, and Mr.
Mhm.
Hatley pay all of those? Or is it?
Temporarily, yes.
Okay, would it be possible to say, what are Mr. Vanden Heuvel's numbers, what are ours, and put a child support and a spousal support order in effect right now with each paying their own bills, and then we backdate what the eventual amount ends up being? I'm just very concerned that we're not going to be able to reach an agreement on this. We're going to be back here in 2 weeks.
Mr. Vanden Heuvel, what's your response to that?
I think we can put together a list of utilities, food, gas. That's easy enough. We can do that. We can put it together. She knows what the expenses are for her kids.
All right, well, I'll just indicate that if the parties have not come to an agreement regarding a interim basic order to cover the bills, and have to come back in a couple of weeks, that I will be awarding attorney's fees to Ms. Reisberg on that one.
Thank you.
Or to her client.
Within
So I
14
really
days.
feel like the parties should be able to get this resolved. At least again, it's a temporary basis. Everything spousal support and child support can be made retroactive, back to February 1st, depending on what those numbers eventually come out with. The court is just concerned that the bills get paid on behalf of the children at this point.
Okay, then could Mr. Vanden Heuvel be ordered to get me that request by Tuesday of next week? If not, I'm concerned I will not hear from him until the last minute.
Okay, can you do that, Mr. Vanden Heuvel, by Tuesday?
Your Honor, I think we can do it by next week, Wednesday.
Okay, Wednesday's good.
Week, so.
Yep. Again, it shouldn't be that hard. I'm assuming that Ms. Hatley has a budget, so it shouldn't be that hard.
So I would
Okay.
think we are still looking for the payment of our attorney fees that were agreed to in the order. I assume there's been payments to Ms. Reisberg through this process. My client would like to have, and they agreed that they would do this together. So we would like
Ms. Reisberg, you didn't respond on that. He did ask for that in his motion.
So first of all, they've been sharing joint finances. The fees have been paid. I don't know what Mr. Vanden Heuvel is owed. I didn't agree. We never agreed to do unfettered access to whatever attorney's fees are out there. So what we agreed upon was an order that the regular bills would be paid, attorney's fees would be paid, but I've not seen any bills. I don't know. The whole status quo is completely burst open. I can't.
Okay. All right. So Mr. Vanden Heuvel, get her a statement of your attorney's fees by Wednesday.
Okay.
And assuming that they're reasonable, the court would be inclined to grant them. So, but Ms. Reisberg certainly has the opportunity to look at them first.
Sure.
But if there's a dispute, then we can hear that.
And we assume that we'll exchange lists then of the attorney fees, so we know what they've paid to from the marital funds.
If Mr. Hatley's if they're still operating under a status quo, then I don't. All right, we'll figure it out.
Thank you, Your Honor.
again, I mean, we may have to figure this out ultimately, because I don't have enough facts at this point, but she's certainly, entitled to some attorney's fees because of her financial situation. And I know she took the 16,000, but,
Sure, and they've got hundreds of thousands of dollars from the sale of their marital home that they both have access to right now.
Well, she has a new home that she's living in now. She's taking her money.
She spent all
again,
that.
I'm reserving on that issue. I'm reserving on that issue. So
Thank you.
I really want to see better communication
Thank
with the
you.
attorneys about this, because a lot of this, there's no reason that it should come to this. So,
Thank you.
all right, we're adjourned.
Shall I
Thank you,
prepare the
Ron.
order?
Yes.
Thank you.
Present in the virtual courtroom. We
Thank you.
have Ms. Damaris, represented by Mr. Vandenhuven, and he is present. We have Mr. Damaris, represented by Ms. Ballast, and they are both present as well. We're here on actually a couple of motions. The plaintiff's motion to clarify the judgment of divorce, plaintiff's motion to change custody, parenting time, and child support. The defendant's objection to the ex parte order that was entered. Let's see, and the defendant's amended motion for execution of money judgment. Why don't we take the motion to clarify the judgment of divorce first, because I think other things kind of hinge on that. And I'll just indicate I've read all of the motions, I've read all the responses, so just try to keep it brief and to the point if you would.
Will do.
All right. Okay, Mr. Vandenhuvel.
Thank you, Your Honor. I think we laid out pretty carefully in our motion as the court has read it. There was one reference, like in that one of I believe it was that a response to that motion that, you know, if it's not in your name alone, then if it's in your name alone, then you're responsible for it. But that's not even good law. I mean, marital debt is marital debt, whether it's individually labeled solely in one party's name, if it's incurred during the period of the marriage. And these bills, clearly, the extra credit card were not taken care of during the mediation. The IRS debt obviously is out there, was not also placed in, and we would ask that this bills, what we're asking basically is fairly easy. Let's, divide the bills. Our request is take care of all these. There's enough money from the payoff of the house by my client's parents to, and that money is being held in escrow, as the court knows, per the court's order, to pay off all the aforementioned bills, divide the proceeds in half of what's left after those bills, pay off the IRS, because this is a joint obligation. There's no doubt you're going to pay it, and the IRS is going to come. They've collected a couple $100s from my client via already. The IRS has. We didn't make a claim about that today. I guess if we can get all the bills divided and this thing can be done, that seems to be a reasonable way to proceed, pay off all those debts. Our office would be happy to pay to write the payments to all the various creditors and remit half the proceeds after all the bills are paid in full. I don't think there's a question that the bills were incurred during the period of the marriage. In fact, the credit card in question was closed prior to the mediation taking place. So there's no doubt it was in fact a marital debt. The IRS, I think, is obvious. Thank you, Your Honor. Was that
balanced? Yeah, that was, I appreciate it. Thank you.
Okay.
Because you do a nice job distilling it. I appreciate it. It's balanced.
I did summarize in my response. First, the taxes that were included in their argument was not included as an exhibit. I have no way of knowing when it was paid, if it was paid, or who it was paid by. And if it was incurred during the 2021 tax year, we attended mediation in 2022. So I'm not sure if there was an extended return, an amended return. I wasn't provided that until the ex parte motion for proceeds was granted, and then that was attached as an exhibit to that. But I defer to the court's decision on taxes. I just don't know how that was accrued and why it wasn't discussed at mediation. Second, the credit card statement that was included shows a date of June 2023, which is clearly post-judgment. I don't have any statements showing when that tax or when that credit card debt accrued, who it was accrued by. Our case closed in January 2023, and my understanding is that Mrs. Domreis did not have employment during that time. And it's entirely possible for her to have accrued $3,600 in debt with no income during a period of at least 8 or 10 months. Last, our mediation agreement did separate debts. There were only 3 marital credit cards. I included as an exhibit to our response the fact that Mr. Domreis became responsible for 1 credit card in his name alone, which was a Capital One card, and the amount of that was $3,061.23. That was part of why the mediation agreement was written so specifically to say there are 3 marital credit cards, because the mediator and the attorneys all understood the other cards were not marital, and that the parties intended to keep some cards separately to themselves, which my client did do. So I would say that their request is another attempt to pay Mr. Domreis less money than what he's owed from equity in the house, which is what Ms. Domreis's object has been this entire time. If the court finds that this is a frivolous pleading based on them attempting to modify a judgment, because there were multiple drafts, which her attorney approved every one of, then I'm entitled to an attorney fee of at least $750 for having to write a response to that motion.
Okay, thank you. As I indicated, I did read all the motions as well as all of the responses. The court holds parties to their agreements. While I understand that at least now the argument is that something was missed or mutually forgotten about at the mediation, I'm going to deny the request to include the credit card because the court has no way of knowing whether or how that all accrued, and I'm not going to reopen the case to try to figure that out at this point. That should have been dealt with at the mediation. As far as the tax liability goes, clearly that is marital based on case law. And I'm not sure why that wasn't dealt with in mediation, but whatever liability is there, it's a marital debt, and that is very easy to determine. So I will grant that piece of the relief and indicate that the parties are to split that liability 50-50.
And can we should we then write all the make payoffs of all the bills, Your Honor, before we disperse proceeds of the remaining bills?
And that seems to be the most efficient way. Ms. Ballas, do you have any objection to that?
I would object on the grounds that their motion for ex parte relief was not due to irreparable harm or injury by my client, and that it should not have been granted on an ex parte basis. However, I understand that we have a pot of proceeds essentially from which to pay these things. I just would have hoped that Mr. Vanden Heuvel's office could have contacted me in advance of filing something ex parte when, to my knowledge, no proceeds existed at the time. We brought our motion for house equity back in June and July.
I'm aware of that, and yes,
Okay.
I would agree that it should not. Anyway, but I do think at this point, it's the most efficient to have Mr. Vanden Heuvel's office write those checks. And again, I've denied that request for anything other than splitting the income tax liability. And I will deny the request for attorney fees.
Okay.
Since I granted a portion of the motion.
Who's going to draft? Would you like me to draft the order, Your Honor?
Yes, please.
Thank you.
Okay, is there anything further?
Yes, we brought our motion and renoticed the motion for payment of house equity to Mr. Domreis. We were forced to bring this back in August. The court denied our motion at the time and said it could be renoticed with no motion fee once the motion was ripe, which was last week. I did back in July and August attach an attorney lien on the property for my interest or Mr. Domreese's interest, and my charging amount at that time was $4,961.41. I was under the impression that Ms. Domreese might have been unrepresented, and there was an auction sale pending, if Your Honor recalls, back in August.
I do.
That amount was redeemed. I'm still coming forth to the court to let the court know my client has not been paid that amount, and that I'm still seeking a repayment of attorney fees for having to bring this before the court again.
Mr. Vanden Heuvel.
My client's, Ms. Domreese's parents paid off, as the court knows, what was owed to keep this property from having an issue. The amount of her attorney lien, I'm sure we could deduct out of proceeds of Mr. Domreese's proceeds at the time. And if I didn't catch it, was $4,900.
Yeah, I can provide you a copy of the lien, $4,961.
Okay, and I'm sure we can take that from Mr. Domreese's proceeds once I do pay all the other bills. There's no worries.
Okay, anything else?
Yes, we have we had one other motion where we were asking.
Oh, right, yes, go ahead.
Yeah. So this motion, and hopefully the court has had a chance to review that motion.
I have. I've reviewed all of it. I've just got a lot of cases this morning, so.
Yep, no, I get it.
But yes, I did review it.
And so a more recent development, my client, the child was not returned at 7 p.m. yesterday as was supposed to be. Child was not returned to my client's custody and care on one of the visits, and that's a concern. Obviously, this next concern is the ADD medicine. She sent a full bottle. It came back and was basically emptied. As the court knows, ADD medicine, there is a secondary market for that. We've addressed the transient nature of Mr. Domreese's living accommodations and the questionable character of the person who he is residing with in the hotel room. And we find that objectionable during parenting time, that he's sleeping with a woman there with the child present. The woman there's been nothing put in the pleadings about this woman's background. I think that she's lost a couple of her children. The disappearance of the medicine is there. It was one of the children's result of incest. There's just, on her side, there's just a whole litany of bad indicators that this is not somebody that should be around when Miss Val's client has parenting time. And the fact of the matter is,
can I ask, was there a referral to CPS?
For which
you're alleging that this person has prior CPS involvement and is spending the night with the children. Did you make a referral for them to look into it?
I did not make a referral yet. I do not know if my client did. I'm assuming not.
Okay, she's shaking her head. Okay, just a question. Go ahead.
Yeah. The other piece is the actual parenting time that's been exercised here is not really a joint physical, but it's been basically in every other week. My client's managing all the medications, doctor appointments, school, all those usual things, which is really what's really happening. And as you know, the Court of Appeals looks to what happens rather than what's said in orders. What's happening is he is not exercising his parenting time regularly. And when it does, it looks like every other weekend is what I think we pled in our pleadings. I'm arguing, by the way, Justin's motion because he's on a different motion today. But that is what's going on here. We're asking that the order reflect the every other weekend as the parenting time has been set up, and that my client be acknowledged as having full physical custody at this point, because that is what's being exercised here. I think for the reasons I mentioned earlier, that makes sense in this context too. And given the fact he doesn't have a regular home right now, that he's been in, living in hotel rooms and so forth. It makes sense in terms of stability for the child as well. Thank you, Your Honor.
Thank you, Ms. Ballast.
First, Mr. Domrese's residence is not transient. I provided as an exhibit to my response the pictures of the child's sleeping arrangements. It's perfectly clean. It's not a dirty hotel room. And yeah, it's an extended stay place because he was never paid equity from the house. He wanted to avoid having to move twice or 3 times because he wanted to save that money for a sizable down payment for wherever he does go to.
Let me just say, I have no problem with his current residence. Extended stay is fine.
Okay,
So
I appreciate that. There was no failure to return the child last night. It's his night to have an overnight. Thursdays are ordered to him per the judgment. Ms. Domres tries to manipulate the schedule sometimes. Sometimes she takes advantage of the fact that Mr. Domres is available. They seem to be co-parenting fairly well together, and I don't think we have what would constitute a threshold for change in circumstances to review custody or even parenting time at this moment, because I think the parties do co-parent well. There's some information about medication. Mr. Domres is fully aware of what medication the child is on. There's never been an empty bottle returned. I don't know why that allegation was not pleaded if it's such a concern. I don't think there's any concern about parenting time. I don't think that his fiance should be a concern. I think Ms. Domres is actually in support of this fiance because she's inquired in several of the texts that were included with their motion about his fiance's mental health and what medication she's on and what medication Ms. Domres has taken. So I think that that's a non-starter. This is just an attempt to try and punish Ryan for having a successful relationship. Child's never been late to school under his watch. By contrast, I think those are some texts in there and emails with the teacher that homework was not being done under her watch. Their requested relief was to go from 120 nights to less than 70. It's clearly not in the child's best interest to sever the relationship with the father at this point. And I again asked for attorney fees for having to answer this because I think that a change in custody at this point is simply not warranted, and there's no threshold shown for either a change of custody or parenting time.
all right, thank you. Again, I've reviewed the motion as well as the response. This is the ink's barely dry on this judgment. And based on what has been pled today, I cannot find proper cause or change in circumstances. That doesn't mean that the court wouldn't take a look at this if something more substantial and provable occurs, but based on what was presented to the court today, I'm going to deny the motion.
Thank you, Your Honor. Would you like me to put that order too?
I did make a request for attorney fees for having to respond to this pleading.
I'm going to deny the request for attorney fees at this time. Certainly, if any further motions that are unsubstantiated are filed, then the court will reconsider that. But I'll ask Mr. Vanden Heuvel to prepare the order.
Thank you.
Your Honor.
All right. Thank you. We're adjourned.
Good weekend.